Good morning. You're Edwania Johnson? And Ms. Johnson was previously in court, entered pleas of guilty in all three of her cases. And I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor. Yes, Judge.
Are there any additions or corrections?
I'd just like to address one thing Mr. Smith had a problem with. It's kind of a law of parties thing on the forgery, I think. And I'll ask my client to clear it up. Now, you're working for a home health care agency, is that correct?
Mm-hmm.
And
Answer yes or no, please.
And your client at the time had asked you to dispose of some personal banking checks, is that right?
Yes, and I took them. I misspoke. I meant to say I took the checks, and I knew that Adrian Hayward was going to cash them, so I'm just as guilty as him.
So, and she said in here that she's the one who took them.
Yeah.
So I'm okay with that.
Brought it up, and
Okay.
I had to figure out culpability.
I appreciate that. Yeah,
And,
I agree.
That admission is legally significant. Even though another person allegedly cashed the checks, Johnson acknowledges she took them knowing what would happen. Under the law of parties, participation with knowledge and intent is enough. The state doesn't need her to physically cash the checks to hold her responsible. By clarifying this on the record, the court removes ambiguity about her role in the forgery.
They've never caught AJ.
No, I've been hearing that he's incarcerated or whatever, but I haven't.
Okay.
Thanks.
Any other issues?
No, Your Honor.
So I would like to know, just so that I know what, if any, conditions, what is the status of children? Where are they? Who are they with?
They're in foster care right now. They wanted Judge Shelton, I think this is his name. He wanted the restrictions of the probation so he'll know how to move forward. But I went to court the 16th for them, and they was trying to dismiss them, but I didn't have paperwork on probation.
Okay. What?
Speaking with Deborah's story, that typically, as a condition of the criminal case, sometimes they put some of the won't abandon and get some of the CPS rules. I didn't see that.
Well, I guess I want to know what the status of, is CPS still involved? Is there a plan in place right now, an emergency?
I spoke with the CPS caseworker, and they wanted to know how these criminal cases were going to resolve. The plan's always been reunification. She's done real well with them, according to her, the caseworker.
So I guess what I'm going to need is, or probation's going to need is, my ruling's going to be that there's no unsupervised visitation unless she's followed through with all of the CPS plan. And so, and that's pretty much what the PSI says, is that their recommendation is no unsupervised contact without authorization from CPS. So if you're doing everything you're supposed to with CPS, and they...
We can go talk to Judge Shelton maybe, or no, this is fine?
No, I mean, that's as long as but she's going to have to give her probation officer documentation from CPS. So you can work that out with your probation officer.
The judge links Johnson's criminal probation directly to her Child Protective Services plan. That means her freedom now depends on two systems at once: criminal court and family court. Even a technical failure with CPS could become a probation violation. It's a layered form of supervision, and it dramatically raises the stakes of compliance.
Mine's going to be no unsupervised unless, and then if probation gets that information and she's doing her safety plan and everything, then we're going to be okay with that here also. But they're going to kind of be the ones that dictate that process, not me.
Just kind of nebulous. A couple conversations with appointed counsel on that, and a couple conversations with the caseworker.
Okay. All right. So, Ms. Johnson. Ms. Johnson, in cause number 24 DCCR 2151, I'm going to find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings in that case for a period of 6 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. In cause number 24, DCCR 2152, also find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings for 5 years. You're ordered to pay a $500 fine in that case and follow all of the rules and conditions of probation. And then finally, in cause number 24, DCCR 2153, find sufficient evidence to find you guilty However, I'm again going to follow the agreement that you made with the district attorney and defer all proceedings for 5 years. There is not a fine in that case, and again, you're ordered to follow all of the rules and conditions of probation. One of the rules and conditions is that you have no unsupervised contact with any child, including your own, under the age of 18, unless CPS says that that's part of the plan and that's where they're working. And once they do that, if they do, you have to get that information to probation. So you can't just say, okay, CPS let me do it and I'm going to start seeing them unsupervised, because we won't know that you have that permission from them. Does that make sense?
Yes, ma'am.
So you've got to make sure and go talk to your probation officer, make sure they know everything that's going on. And so part of your probation is that you are required to comply with all the conditions that CPS is imposing. So if there's still any classes you have to do, whatever it is, that's now also part of your probation. Does that make sense? So if you do everything that you're supposed to while you're on these probations, then this is an excellent opportunity, because you don't have the felony convictions on your record. And at the end of the probation, if you do everything that you're supposed to, then the cases will actually be dismissed and you'll never be a convicted felon. The other side to that, though, is that if you violate any condition of probation, you can be brought back into court. You can be found guilty of each of the offenses. In that forgery case, you could be sentenced between 2 years and up to 10 years. And in those injury to a child cases, you could get up to 2 years in a state jail prison. Do you understand? In all of those cases, I'm handing you the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. You just need to have a seat here in the courtroom. Probation's going to call you up when she's ready to go over all of your paperwork. All right? Good luck to you, ma'am. Thank you, Mr. Fraser.
Edwania Johnson entered this courtroom having already pleaded guilty to 3 felony cases, 1 forgery case, and 2 injury to a child cases. The judge reviewed the pre-sentence investigation report and confirmed there were no material disputes that would prevent sentencing. Early in the hearing, Johnson clarified her role in the forgery offense. She admitted she took checks from a client while working for a home health care agency, knowing another individual intended to cash them. Even though that person was not apprehended, Johnson accepted responsibility for her part. That admission solidified the legal basis for holding her accountable under party liability principles. But the criminal conduct was only part of the picture. Her children are currently in foster care, and Child Protective Services remains actively involved. The standing plan is reunification, but only if Johnson complies fully with CPS requirements. Recognizing that overlap, the judge made a critical decision. Probation in these criminal cases would be conditioned on full compliance with the CPS plan. That includes parenting requirements, documentation, and strict limitations on contact with her children. Specifically, Johnson is prohibited from having any unsupervised contact with any child under 18, including her own, unless CPS authorizes it and probation receives formal proof. That condition places her parental rights and her freedom on parallel tracks. The court then imposed deferred adjudication in all 3 cases. In cause number 24 DCCR 2151, the judge deferred proceedings for 6 years and ordered a $500 fine. In cause number 24 DCCR 2152, proceedings were deferred for 5 years with another $500 fine. In cause number 24 DCCR 2153, proceedings were deferred for 5 years with no fine. In each case, Johnson must follow all rules and conditions of probation. Legally, deferred adjudication is both a second chance and a suspended consequence. This case highlights how deferred adjudication operates as a bridge between punishment and opportunity. It allows a defendant to avoid permanent felony status, but only through strict adherence to every condition imposed by both criminal court and CPS. Do you think tying criminal probation directly to CPS compliance increases accountability? Or does it make success nearly impossible? If you appreciate clear, fact-based courtroom breakdowns like this, make sure to like, comment your thoughts, and subscribe for more in-depth legal analysis.